All right, everyone. Hello. How is everyone doing today?
Oh,
Good.
wonderful. It's a wonderful day.
Beautiful. Hey, I'm sorry for the casual nature of my dress. I'm surprised I was actually able to make it. I'm supposed to be working today in my Colorado office, and if you look outside, this is my hotel room. Oh, sorry. I've got the background on, but it's snowing and blizzarding, and my flight was delayed. Man, it was close. I barely made it to my hotel in time and didn't have a chance to put gel in my hair and put on my shirt. So hope you forgive me for my casual dress today, but I'm ready to rock and roll on this rogue board member discussion we're going to have today and give you some good insights on how to deal with rogue directors. That's the main topic. So before we begin, a couple of things. First of all,
Trying to get it, honey.
let's make sure everybody's on mute so we can keep it clean. There we go. Number one, we've got a lot of folks on today that represent different communities. So whatever I say today is not legal advice. So what does that mean? It means if you want to talk to your boards about what we discussed today, it's not technically attorney-client privileged, which means anyone can hear it, listen to it, look at it. So just keep that in mind. If you do want an attorney-client privileged communication, you can reach out to me separate and we can certainly go from there. That's number one. Number two, is the chat function. I'm going to be asking you guys in just a minute to put down your craziest rogue director experience. And if you can, write that in the chat, because we're going to review a few of your craziest things and apply the law that I'm going to discuss in just a minute. And then how we could handle each of those, because I would guess that most of you have either a very similar experience or something that you can relate to everyone else, which would help everyone. Okay, yeah, you're right. I'm getting some few chats directly to me about my look today. Again, if you're just joining, I didn't have a chance to change out because I literally walked into my hotel room.
You look good. You look good. You look normal, not very, straightforward.
Well, that could be a good thing, could be a bad thing. Maybe some people expect the attorney to be buttoned up, right? But this is how I normally dress. So it feels good to be this way.
It's appropriate for the background.
Yes, that background looks amazing. Wish
Yeah.
I was in Colorado right now.
It's crazy right now. It's negative. Well, it's 20 degrees outside here where I'm at in Denver. And then in the mountains right now, it's -5 with wind gusts of 80 miles an hour.
You should be skiing right now.
No, not in 80 mile an hour winds. I shouldn't. We'll see. Maybe in the weekend I might, depending on how much snow drops. So, okay, very good. As you all know, I love to start with stupid laws. Since I'm in Colorado, let's do a couple in Colorado. This is a great one. I wish we had this one in Arizona. This is a law in Boulder, City Code 5-4-16. I'm going to read it to you. It says, frankly, I don't think this is stupid. I think it's great. Outdoor furniture restriction. No person shall place, use, keep, store, or maintain any upholstered furniture not manufactured for outdoor use, including without limitation, upholstered chairs, upholstered couches, and mattresses in any outside area located in the following places: in any front yard, any side yard, any rear yard, any balcony, or any patio. So basically, if you manage condominiums or planned communities in Boulder, Colorado, you can say when they put a couch in the patio, can't do that. That's against the law, and make a code violation for them to enforce it. Not too many laughs there, but it pretty interesting. In Denver, here's the last one. In Denver, it's illegal to mistreat rats. There's a law that prohibits you from mistreating rats. What that means, I don't know if that means we have to capture them humanely or what that means, but all I know is it says it's illegal to mistreat rats in Denver, Colorado. So, all right. So without any further ado, let's talk about rogue directors. For those of you that have had an experience with dealing with rogue directors, feel free to put it in the chat. And while I'm covering what the law currently says about rogue directors, you put your comments in the chat and then we can review some of those and have a group discussion at that point. All righty. So when it comes to rogue directors, there's actually a case in Arizona. It's called the McNally v. Sun Lakes case. And some of you have heard me maybe talk about this, but there are several things that we get out of this case. To take a step back, McNally actually won that case in the Court of Appeals. She was the quote unquote rogue director. But the Court of Appeals also addressed some of the things that a board should and can do when it comes to dealing with rogue directors, because reading between the lines, I could feel that the court was sympathetic to the board for what McNally was doing in that case. Now, that's my opinion. If you read the case, you'll probably come out to the same conclusion, especially with what the court said. But let's get into it. So McNally was on the board in Sun Lakes. McNally, from what I saw, she was about transparency, and that's kind of what she ran on to get elected, was, oh, we want to make sure we're transparent with the entire community. That was the story, and we hear that occasionally. Well, once she got on the board, she started disclosing information she should not disclose, which freaked the board out. Executive information. All of the executive information you could see potentially in an executive packet was free game for McNally in discussions to the non-board members. So if you've ever had this experience of a director sharing delinquency lists, violation lists with the entire membership, you understand the problem that can create. So the board rightfully, in my opinion, freaked out. So they immediately went to their manager and the manager went to their attorney. So what do we do about McNally's disclosure of executive information? We got to keep this stuff secret. And so they asked her kindly, hey, can you please stop disclosing all this information? It's a problem. It can cause liability, because if you're disclosing certain things and one of the members in the community, let's say it is a delinquency list. If I'm on that delinquent list and maybe I just paid my dues and it's not updated yet, and everyone now thinks that I'm a deadbeat debtor, that's a problem. And if I don't like it, what if I, at that point, sue for defamation or for wrongful disclosure or whatever it might be? So the board asked her through their attorney, please stop. She didn't. She refused. She said, hey, look, I ran on the issue of transparency. That's what I'm going to promote. That's what I'm going to do. And so the board ran back to the attorney, and the attorney basically said, well, we can't give you executive information anymore. In fact, you cannot participate in executive meetings because you can't keep everything executive, despite our request you not do it. Sounds reasonable enough, right? Well, these particular bylaws said that if a director's obligated to go to meetings. And so she pointed to that provision in the bylaws and said, hey, look, I'm obligated to go to meetings. That's my duty as a board member. You can't ban me from attending executive meetings. So to make a long story short, the board said, well, yeah, that's true, through their attorney. That's true, but you forfeited that privilege because you're breaching your fiduciary duties to the corporation by disclosing all this information when you shouldn't be. So McNally turned around and sued the association. And it went all the way to the Court of Appeals. And the Court of Appeals ultimately agreed with McNally on a couple of points. Number one, the court said, hey, listen, okay, reading between the lines, like I said, we sympathize with you, board, but in order for the board to act and do this, basically disqualify the board member from attending executive meetings, or basically make them a lame duck director and disqualify them from even being on the board. So essentially, de facto kicking them off. The court said, you can do that, but you have to have express permission in the articles or bylaws, because the nonprofit statute says that the articles and bylaws can prescribe qualifications to be on the board. So the Court of Appeals said, okay, let's look at your documents and see what it says about what you did. And they couldn't find anything in the documents, the bylaws and articles, that said when a director acts this way, you can do what you did. So if those bylaws or articles had actually given the board express permission to do that, what they did, then I think we would have a completely different holding in this case, and that would be great for us, but they didn't. And the Court of Appeals said, look, all the bylaws and articles really say right now is that actually they're obligated. They have a duty to attend these meetings. So that was the end holding. They ruled technically in favor of McNally. But then the Court of Appeals said, look, this is what a board can do when their documents are silent. Number one, ask them not to disclose information kindly. And hopefully they agree with you not to do it. But we all know that in situations, especially when you're dealing with certain individuals, that can be difficult, if not impossible, but it doesn't mean you shouldn't try. That's always going to be step one. Ask the board member to stop doing what they're doing and let them know it's a breach of their fiduciary duties to disclose information that the board doesn't otherwise approve, especially when it's executive in nature. So that's number one. The court then went on to say, if it is of a fraud or theft situation, the court or the board can file and ask a judge to remove that board member from off the board. Remember, this is important. Keep in mind what I said. There's two terms I'm using. One is disqualification, and another one is removal. So keep that in mind. I think there's a very clear distinction between the two we'll talk about in just a minute. So that's what the court said. It said, if a board member is stealing money or engaging in fraud on the corporation, there's actually statutes that allow the association to file a request with the court to absolutely remove them from off the board. But that wasn't the case here. We didn't have a board member stealing money. We didn't have a board member committing a fraud. We had a board member that was engaging in unauthorized disclosure of executive information, which probably for all of us is what we're talking about 90+% of the time. So what did the court say next? The court said, all right, one, if you've asked them kindly to stop disclosing the information, they haven't done it, and it's not a fraud or theft situation, you can file a claim with the court for what's called an injunction, ordering the board member to have a gag order placed on them, to where the Superior Court judge will enjoin them through an injunction from disclosing executive information. We all know that process, however, does require us to file on the association board's behalf, and it can take a little while. Now, since this case came out several years ago, we've had a dozen or so of these cases where we will actually file with the court, and depending on what is being disclosed, sometimes we will ask for an emergency order called a temporary restraining order. And other times we'll just ask for a preliminary injunction. The difference between the two is if you have a board member disclosing things that can cause immediate harm to the association, where there's grounds to get an order like today or tomorrow or next week, we file a couple of extra pleadings with the court for a temporary restraining order, where the court, sometimes even without letting the board member come into the court to explain themselves, will sign off on that order, ordering them to immediately stop talking and disclosing information. And once it's served on that board member, they're obligated to comply with it. Now, when that happens, the court makes us come back in with that person, with the defendant, pretty quickly to establish additional evidence to keep that in place, and then eventually get what's called a preliminary injunction against them, which is converted to a permanent injunction, which lasts for a lot longer. But you can get emergency temporary relief that bridges the gap between the time you file a complaint for injunction and the time that the court actually has a trial on what happened. But the facts have to be significant, and it is case by case. You got to it's based on the specific facts that are going on. If the facts don't justify a temporary restraining order that's filed by and signed by a judge the day of or very soon after we file an action with the court, there's what's called a preliminary injunction. And that process is when we file an action against the rogue director on behalf of the association, and the complaint and the accompanying document pleadings with the court say, Judge, we need to have an expedited trial on this. And before you enter a permanent injunction, we want a preliminary injunction, which takes usually normal litigation on these take about 2 years or so. It consolidates it all into about 4 to 6 months. So what the judge will do is the judge will say, okay, I'm going to sign an order that requires the defendant and you to come in to basically my courtroom within the next month and give me an update. If you haven't resolved it, then I'll set it for an evidentiary hearing in the next 3 to 4 months out, where we actually go to court, have a mini trial, and if we prove that the director's engaged in rogue activities, the judge then, pursuant to this McNally case, would enter an injunction, the preliminary injunction against the director. And if we can get a preliminary injunction against them, ordering them to stop doing what they're doing, there's a very, 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 very high probability that we're going to get the permanent injunction as well. So you basically win the case. That second option for injunction, instead of getting it on the day of or shortly thereafter under the temporary restraining order one that I just talked about, the next one, we don't get the injunction for 3, 4, 5, 6 months. But so there is that possibility that they'll continue to engage in that behavior, but that does nothing but helps the association prove that that director is in fact rogue. And once the judge enters that order, if we can show the judge that the director is unreasonable, your chances of getting most of your attorney fees, if not all of them, awarded, especially if the judge feels like the board is the reasonable party, you're going to get reimbursed your attorney fees in the amount of whatever the judge feels is reasonable. It may not be all of it, but it may be a substantial portion. And if the judge thinks you're acting unreasonably, you're probably going to eat fees. But that is what the Court of Appeals in this case said you do, that is the process. So reading between the lines, let's go back to what I said at the very beginning of how this case could have had a different outcome. The hinge point on this case was really what the documents said. And like I said, based on the holding of this case, I'm convinced that if the bylaws or articles gave the board the express permission to do what they did, i.e. ban McNally from having executive information if she was disclosing this in a rogue manner, I'm convinced the Court of Appeals likely would have ruled the exact opposite. Because if you read the McNally v. Sun Lakes case, that was what the court relied on. And then all this other subsequent conversation we've had about what the board can do in the event of a rogue director was what the Court of Appeals gave the board and boards in Arizona when you don't have express authority in the documents. So what does this mean? In this new landscape, what it means is some communities will amend their bylaws or articles to incorporate codes of conduct so that if a board member is rogue and violates one of their express duties in the code of conduct that is in the bylaws or articles, then the board arguably can disqualify them from sitting on the board. There's that word again, right? Disqualification, not remove, disqualify. So now let's talk about the difference between the two. What is disqualification and what is removal? Disqualification, here's the simplest way of thinking of it, which all of us can understand. When the bylaws and articles require you to be a member to be on the board, we all see this all the time, right? What happens to that board member when they put their house up for sale and they move out of the community after they sell their house? They're no longer an owner. So they're no longer a member. And when the bylaws require you to be a member to be on the board, are they still on the board? No, they're no longer on the board. And the members didn't get together to vote to kick them off through a removal process like the statute talks about. they're automatically disqualified because there's the qualification to be on the board is you have to be a member. So if they're not a member, they're no longer on the board. It's an automatic function. So you automatically have a vacancy on the board and you fill that vacancy pursuant to what your governing documents tell you to do. Typically, the quorum of the rest of the board gets together and fills the vacancy. Okay, so that is disqualification. Removal, on the other hand, happens when right now the statutes say you have to have the members that want to remove a board member sign a petition to remove. And if that petition is validated and meets the statutory requirements, which is, what are those? It's a conversation for another class. Go on our YouTube channel. I think I've got a removal class on there. If I don't, we can do one later if you want. But the removal statute is very clear on what has to happen to remove. Number one, you have to have a petition signed by the members that meets the statutory requirements. Assuming you do, then you have to call and notice a special meeting of the members to vote on whether to remove or keep the board member. And if there's quorum and simple majority of quorum in that process, that board member is voted off the island. That's removal. Can you see the difference between disqualification and removal? So now here's the caveat. We do not have case law yet. Unfortunately, because McNally's documents were silent, we would have had case law on this issue. But because McNally's documents were silent, my discussion with you about disqualification is not binding case law yet. So some HOA attorneys will say the removal statute trumps all. So if you ever want to kick off a board member from the board, you have to have member vote pursuant to the statute. I would agree with them on certain facts, but other facts I disagree because of this McNally case. So taking disqualification to the next step, we had that very clear example of when the bylaws require a member to be on the board. And then when they sell and they're no longer a member, they're automatically off the board, right? They're automatically disqualified. What happens then when you amend the bylaws or the articles to incorporate the code of conduct? So let's go back to this McNally case. Let's say that the membership amended the bylaws or articles to include a code of conduct and incorporate a code of conduct that said you cannot disclose executive information. You have to, and incorporates their fiduciary duties under case law, like their fiduciary duty to the corporation act in the best interest of the corporation. But let's say it said, and you have to be in good standing. Some of your guys' bylaws, by the way, and articles have this requirement that to be on the board, you have to be in good standing. You can't be delinquent. You can't be in violation of CC&R provisions. So if I'm on the board and my bylaws require good standing and I decide to go build a 2-story home in a single story home family community, I'm clearly in violation of that CC&R provision. Can you kick me off the board? Am I disqualified? So the rest of the board gets together and says, Clint is rogue because he's either delinquent or he's in clear violation of the CC&R requirement that it'll be single story, but he's building a 2-story. Yes, arguably, absolutely. There's a very good faith argument that the remaining board can get together and kick me off the island as disqualification because an express provision in the bylaws or articles have been violated. Changing a little bit. What happens if a code of conduct is in the rules? Not the bylaws, not the articles. Can they kick me off the board? The answer is for condos is clearly no. Because the Condo Act says that any qualifications to be on the board have to be voted on by the members. So a rule is adopted by the board. So you can't kick me out. There can't be a disqualification event, technically, in my opinion, if you're in the condo. The Planned Communities Act doesn't say that same thing. So is there an argument you could kick me off with a rule? Could a code of conduct be a rule instead of the bylaws or articles? maybe, but I'd say no. If I were litigating this, I'd say no. If I were the judge, why? Because again, this McNally case didn't care about what the rules said to disqualify McNally. They cared about what was in the bylaws or the articles, because the Nonprofit Corporation Act has an express, clear provision that authorizes those bylaws or articles to contain qualifications to be on the board. So it's my opinion that if a board wants to put code of conducts in place with teeth, so you can have rules that have code of conduct or whatever, but what happens if there's a breach of that code of conduct? If you want to have teeth in it, they really should be in the bylaws or articles. Now, I've actually litigated this issue in the trial courts, the lower courts now, several times since McNally, my firm has. And I've stood in front of judges and I've argued that the board member is disqualified. And we've won these cases. So because I use the McNally case and I use the fact that the code of conduct is not a rule, but the members voted on it and the members have amended the bylaws or amended the articles of incorporation to include it. And when you combine the McNally case and the dicta that court had with regard to what they would have done had that been expressly in there, then it comes out to a very persuasive argument for trial court judges. That being said, I've got some friends at other firms and they say they've tried it, and I want to say a couple of them weren't really successful with it. So until we have case law, technically, this is a gray area, but I'm just telling you, when you're dealing with rogue directors, there's a very good argument that you can kick them off the island as a disqualification if they're an express violation. At the very least, let's go back to McNally. At the very least, even if you wanted to avoid kicking them off the board or disqualifying them from being on the board, if your code of conduct said that if you're expressly disclosing executive information with our board member, you can no longer have access to that information, you're not kicking them off the board. They could still be on the board. They just can't have access to executive information, because that's what McNally happened. The board would allow McNally, from what I recall, to attend open meetings where they're in the open, but not the executive meetings. So if they had express authority for that, they technically could have done it, like I said, under this case. All right. With that background, then, let me summarize. Again, if your documents are silent, if you came to me, I would say, let's amend the bylaws or articles, depending on which is easiest to do, via membership vote, to incorporate a code of conduct with teeth that if they engage in rogue activity, the association's board, the remainder, can disqualify. Then the rogue director who's disqualified from serving on the board, their argument, in my opinion, is not necessarily, oh, the bylaws are a problem. Because the trial court judges, at least the ones I've litigated in front of, are all okay with those provisions so far and have upheld them. The better argument is whether the board acted reasonably in kicking the rogue director off the board, disqualifying them from the board. If I was an attorney that represented the homeowner, that rogue director, that would be the best argument to make, is whether the board acted reasonably. So if they had the express authority in the bylaws or articles to kick them off, okay? So that's number one. If your governing documents don't have something in them and you want to add teeth, amending the governing documents to give you the express authority to do what they tried to do in the McNally case. Number two, if you can't do that, or you don't have them in there right now and you just have a rogue director that's engaging in disclosure of executive information, if you haven't asked them nicely yet, ask them nicely to stop doing it. If that doesn't happen, then we can get formal and send them a letter. If they continue to do it at that point, the court has clearly said that you can then get an injunction against them, ordering them to stop disclosing. And whether you get an emergency injunction issued like that day or in 4 to 5 months after you file the case depends on how much harm that disclosure is doing the association. And that's just going to be, like I said, a case by case, fact by fact analysis with me and you. All right. Another couple of things the court said. Here's a big question that comes up that we sometimes get. Let's say I've got several at our firm, board members who are disclosing things or who are making threats to sue the association for whatever reason. And the rest of the board needs to get together to discuss that threat. All right. So last week, for example, we get an email, manager gets an email from a board member. I'm going to sue you if you don't do X, Y, and Z. Okay. So the board needs to get together to talk with their attorney about what to do about that case. Is the board member that's threatening to sue authorized to be in that meeting and hear the legal advice I'm going to give the board? And the answer is no. So in this McNally case, it's pretty clear in the footnoted areas and the dicta that they said there are times when you can have a meeting without the board member there. And they gave the specific example of when there is an actual claim that they're making against the association. It would be stupid, and I'm going to use that word, stupid, to allow a rogue director in a board meeting hearing the advice and the defense and the litigation strategy about their own claim. Not to mention the fact that that's a clear breach of their own fiduciary duties as a board member. And so let's talk legally about why that is. Why is it? Frankly, I'm surprised. I've actually heard HOA attorneys say that that board member should be there. And I'm like, are you kidding me? That's the dumbest thing I've ever heard. You should not be an HOA attorney. So here's why. One of many reasons why. Number one, if you allowed that rogue director to be part of that meeting, you are damaging the corporation. Because the corporation, the fiduciary duties a board member owes are to the corporation, not themselves. And if I, Clint, am the rogue director threatening to sue the corporation and I'm demanding to be part of that meeting, I'm not there representing the corporation's interests as a board member. Excuse me. I'm only there representing my interests as an individual to sue the corporation because we wear many hats. I take my board member hat off. I put my homeowner hat on. So any homeowner that is there or any board member that's there that wants to sue the association and is there attending an executive meeting to get advice from the attorney about how to defend the association isn't there as a board member. Thanks. Yeah, that's why I have a hat on. Somebody just texted wild hair. You're right. Sorry, I should have taken my hat off. So anyways, they're not there as a board member. They're there as
I'm
a
just
homeowner.
messing with you, Clint.
I know, Maria. I know. That's why I laughed. That's why I even mentioned it. So you can see the point. And I'm shocked when I see attorneys, especially that focus their area of practice in HOA law, give boards advice that they have to allow a rogue director, or maybe not even a rogue director, but a director who's making a demand on the association that they have to be in that executive meeting when they're getting legal advice about that very same claim. If you've got an attorney that's saying that to you, get a new attorney. Okay. Now, let me get off my soapbox for that. But that is a very clear example of when you're not disqualifying a board member from being on the board. You're only prohibiting them from being in a meeting. Why? Because it involves a direct claim. Same thing about what happens if you need to talk about and make a decision on them going to the attorney for foreclosure because they aren't paying their dues. Do they have to be in that executive meeting to make that decision about whether they themselves are going to be sent to the attorney for foreclosure? Same thing with violation and covenant enforcement. Those are very clear examples of when you can avoid them being part of the meeting. That happens all the time. Okay, so that is the background on the McNally case. Now, for the next 20 or so minutes, I want to review your chats on specific examples that you've had where we're dealing with a rogue director, and we're going to apply the analysis that we just went through to that specific example. Okay, so give me 1 second while I read through the chats and I pick up a couple of them to start with. And if you haven't put an example in, please do. All right, let's start with this one. I don't care what the state statutes say. I'm going to do whatever I want to do. I don't have to follow the laws. Apparently that was said in an open meeting with 45 people in attendance. Clearly a rogue statement, clearly a breach of their fiduciary duties to act in the best interest of the corporation, to act in good faith, and all of the above. So what do you do about that? In this scenario, you definitely want to have a conversation with that board member. Sounds like they're pretty obstinate. You've already done that. So has the board had training with the attorney yet? I do, if they're a current client of mine, I do one complimentary training a year, either in person or virtually. If they're not a client, they can become a client. We can do that. That sometimes helps. Sometimes it doesn't. If you've got a director, and I see this more as presidents for whatever reason. I don't know why it is. I'm the president of my board. Hopefully I never act rogue, but usually it's the president that's, I'm going to do whatever the hell I want to do, making that statement. But anyways, they make it in an open meeting. That's a problem. They're making an affirmative statement in an open meeting to the members. Let's say, I don't know what all the facts are on this one, but let's just say we're talking about an owner that's getting selectively enforced because this president hates that owner and their neighbors, and they can't stand each other. And the neighbor has a basketball hoop in the driveway, and the president lives next door, really is pissed off at that. And they have a rule out there that says no basketball hoops out there for more than 48 hours or whatever. And one day they left it out there for 49 hours instead of the 48. And they removed it. It's no longer there, but the board president wants to sue him now. And you're like, dude, no. And the board president demands it. Well, that's not the board president cannot make decisions on behalf of the association. It's the board that makes those decisions. But when you have a president, let's say that's what this example is, and they're saying, I don't care, we're going to sue you in an open meeting. That's a problem. And that is just, here's what the homeowner's attorney does as they're getting ready for trial with a big old smile when they put that president on the board and they have witnesses impeach that president of what he said about his breach of his duties or whatever it is. It's a bad, bad thing to do. And I would have that remedied as soon as possible. Do not allow directors to make affirmative statements about the law in an open meeting. Oftentimes they get it wrong. Do not allow rogue directors to make stupid statements like this in open meetings. And I know it happens. So what do? We're talking about how you can avoid it in the future. Well, I would personally try to do those things first, training, ask them nicely. If they're completely obstinate, like, no, I'm not going to do training, I'm not going to do this. And they're like, they get a letter from me and they're not even willing to come to the table. I might convert my board meetings, but the rest of the board make this decision to convert all the rest of the meetings to go virtual. And then when they're on virtually, they do not have hosting powers. You can mute them and keep them muted until it's time for discussion on a pending motion for board discussion. And the second that board member starts acting beyond the scope of what they're there for, you mute them again. That's one of the ways you can do it. That's one of the effective ways I've seen them doing it. And by the way, I don't see any problem with that with the courts. The courts are okay with that when they're acting rogue and in clear breach. Now, can you go to court and sue him and tell him he has to have a gag order? He can't be making these kind of spontaneous statements in an open meeting. Yeah, you can. Are you going to? Probably not. It kind of depends on the absolute, what is at issue here. If it's something that could cause significant harm to the association, that's when we may need to go get an actual formal gag order. But there are alternative things you can do, like I said, making it virtual. If there are bylaw provisions already, disqualification may be an option. So there you go. Another one here. There's a board member who is catfishing everyone on Facebook and social media. They have one social media account that is their real name, And then they created a new social media account that's just a fictitious name so that they can post all sorts of garbage on Facebook about the board. Interesting, right? Well, step number one, we already know that that board member knows he's rogue because he just changed his name and he's acting with a fictitious name. But even if that board, you see this all the time too, whether they are catfishing or whether they're just posting crap as a board member on social media, you have to keep two things in mind. One, is that post being posted as an owner or is it being posted as a board member? If they're disparaging the board, if they're harassing the board, if they're engaging in that sort of activity, there are other options that you have that we haven't talked about that we will. Harassment is a real thing with rogue directors, whether it's harassment of other members in person, on social media, on at open meetings, executive meetings, email abuse with managers, because we all see sometimes directors or members abusing you, abusing me, harassing us all, leaving profane and threatening voicemails. So this is the type of person we're dealing with on social media. What are the things you can do? Well, in that scenario, it depends on the facts again, but oftentimes now the courts, not the superior court, but the justice courts have gotten very good at entering injunctions prohibiting workplace harassment against rogue directors. Now, let me explain a few examples. I'm going to go beyond this specific example that I just started with, but it's important for us to understand generally what injunctions prohibiting workplace harassment are and how they can help. So let me start with me being creepy ex-husband, and I love to text all sorts of really bad things to my ex-wife, and I show up when I'm drunk on the doorstep and I pound on the door and I yell and scream, and I'm just a jerk. Okay. And frankly, I'm harassing my ex-wife. What do you do when that happens? What does my ex-wife do? Now I'm happily married. This is just an example. I've been married for 24 years now. Love my wife. I never do this. At least I hope I don't. But what do you do with ex-husband if you're the ex-wife, or you're the ex-husband when your ex-wife?
You block
harassing
them.
you? Yeah, you block them. But if it gets really scary, you go down to the justice court and you get an injunction against harassment against them, which says they can't contact you. They can't come within X number of feet from you. And what happens then after they're served with that order and they do it, they violate it? When you call the police, what do the police do? They handcuff and they haul them away to jail because there's a binding court order that restrains me as ex-husband from harassing my ex-wife. And if I violate that court order, I go to jail. All right. Is there something like that for associations? Is there something that would allow us to have a rogue director, if they violate an injunction against harassment, go to jail? Well, there's two things. One is if one director has a restraining order against the other director. And when I say restraining order, by the way, I mean injunction prohibiting harassment. That's the legal term, injunction prohibiting harassment, but a lot of people refer to them as restraining orders. Okay. So when one director, let's say John, who's on my board, has a restraining order against me, Clint, because I'm harassing John and we can't stand each other. If I go over to John's unit and I bang on his door at 10 p.m. at night and start screaming outside and he calls the cops, I'm going to jail because I'm harassing him in violation of the order. But that applies when you're dealing with a warm-blooded human being, individual versus individual, but not an entity. An entity doesn't have an injunction against harassment. Entities can't be harassed technically. But we have a very similar claim called an injunction prohibiting workplace harassment. It's almost the exact same thing. Just look at it from the association being a workplace. It's a nonprofit corporation. So the members, the manager, the board members are treated essentially like employees in this context. So workplace harassment, up until a couple of years ago, when we started using these a lot more lately, obviously, because more and more people in a post-COVID world are losing their minds. So these are being filed a whole lot more than they used to be. But all of us in a workplace are protected from being harassed, whether it's sexual harassment or any type of harassment. You don't need to take abuse from a board member. We get these against board members all the time that are emailing harassing statements, leaving harassing voicemails, accosting vendors that are show up on the property. You name it. We will go down to the court. We'll get the exact same thing, essentially, an injunction prohibiting workplace harassment. And they're pretty quick, assuming you got some good facts. We file the application, the court might call us. We might need to have a witness testify on telephone call. And then judge signs it, we get it served. And if that rogue director engages in any activity that's harassing at that point, interfering with our vendors, sending additional harassing emails or whatever it might be, we do the same thing, call the cops. And if there's a binding order in place, same remedy, same thing happens, same consequence. That board member may very well be arrested on the spot if there's been a violation of that court order. They're very quick, much quicker than going to Superior Court and doing an injunction, like the injunctions we were talking about before. Like I said, I think all in, you're probably around $2,500, and that would include a hearing. Because what happens there is the Justice Court judge signs the injunction, and that process is pretty quick because we get the application together, we put the witness names down, we file it with the court. Within a week, we'll have it, and then we get it served, or sooner. And then they automatically, because there's such significant consequence for violating it, they have a set number of days to ask the judge for a hearing to quash that injunction prohibiting workplace harassment. And the judge automatically sets it for a hearing where they can come in and present evidence to the court as to why they think the judge should quash it. But when we do those hearings, they're pretty quick. They're usually either an afternoon or a morning. There's not a lot to it. And 99%, I shouldn't say 99, 90% of the time, we're effective in keeping the order in place, because as long as we do enough groundwork at the beginning to convince the judge to sign it, the judge is typically there saying, oh, okay, yeah, there's a problem here. I'm going to keep it in place and I'm not going to quash it. So all in, even for that hearing of 3 hours in the afternoon or 3 hours in the morning for on a hearing to quash, much less expensive than the standard injunction route, like we talked about. Injunction route in the Superior Court was more for when board members aren't harassing others. They're just disclosing executive information. They're acting rogue in that manner. But the second you throw in health and safety, you can go this other route with the injunction prohibiting workplace harassment. Now, today's conversation is about rogue directors, but make no mistake, you can do the exact same thing against any rogue homeowner. Another thing that just happened recently, some of you may have attended my Bent Learn at Lunch seminar, the Bent case, where one board member sued another former board member for defamation and won a $1.5 million judgment against that former rogue member, who was saying all sorts of defamatory things about the remaining board member. So there are defamation cases that you can bring. Those aren't on behalf of the entity, though, the HOA. Those would be individual and individual, and that's not where we step in. We don't sue for defamation because we represent the entity. But again, we can sue on behalf of the association for workplace harassment. We do it all the time. It's a fantastic way to stop harassment. So when you have these come up, feel free to shoot me an email and we can go over the cases. But again, just like the other ones we talked about, it's a case-by-case basis. It depends on the facts of whether you're going to get the injunction prohibiting workplace harassment. All right. Let's see here. What time is it? It is 12:50. an emotional support rat. I don't know. That's a conversation for a Fair Housing Act class. Speaking of emotional support rats, some of you may have attended my class. I don't know. Some of you are probably CAMs. When we teach the fair housing class, over at AACM, I love to give you my examples of the emotional support parrot and the emotional support boa constrictor, both of which were real life cases from the East Coast. And the parrot loved to whisper in the disabled ear, "It's okay. Keep calm. It's okay. Keep calm." And apparently the boa constrictor would be always wrapped around the neck of this individual. And the boa constrictor, according to the disabled individual, alleged that it was trained to sense when epilepsy, when they were going to have a seizure, and it would constrict his neck ever so slightly to stop the blood flow a little bit, to stop the seizure.
I need one of
Crazy.
those parrots every day to tell me it's okay. Don't worry. It's just work.
Yeah.
Board
Hey, you
members,
probably could
don't
have it on their
worry.
shoulder. Yeah, emotional. I know on the East Coast, they said it was an emotional support parrot, service parrot. It was mostly, it was at the time service parrot. Now we don't have service parrots. Now under the new HUD policies, it's only a service dog, but it would be definitely a support animal. And you might even be able to have that on your shoulder at work. Even if you got fired for it.
I'm
that's a
going to talk to
perfect claim.
Tom and tell him I need a support animal to tell me these rogue board members.
Yeah, for sure. All right, folks, let me go through a couple more of these examples here. I've had a board that is 3 members and the VP allows his wife to have access through his account to the board portal. She, the wife who's not on the board, shares that information on Nextdoor. He also uses his position on the board to have his neighbors send violations if he doesn't like them. So that's like that basketball hoop scenario I gave you, right? Convince the president to give him an open-ended parking variance. Okay. So basically enforces the rules where he wants to and doesn't where he doesn't. And at the same time, he clearly is allowing a non-board member to access executive information. Everything we talked about with McNally is in play here. If you're wondering whether the wife can have access, the answer is no. The wife cannot. The wife is not on the board. We sometimes see this too all the time. We're like, let's say there's an executive meeting and it's virtual and the board members sitting in one room and the living room and spouse or significant other or whoever's in the same room hearing the conversation. That technically shouldn't happen. It happens all the time. We have to admit that. But from a legal standpoint, that shouldn't happen. It should only, executive information should only be amongst the board members. So how do you stop that board member, according to the analysis I gave you, from allowing wife access to the portal? Do you just shut off his access to the portal? If this were in the McNally case territory, I think you could if, what's the big capital I, capital F?
If it's in the government.
Not just the governing documents, if it's in the bylaws or articles. I think you could. What happens if it's not? Then we just go through that formula the court gave us. 1, ask him to stop doing it. Ask him with your attorney to stop doing it. Do board training. Hopefully all those nice little cushy, fluffy things happen and the board members just like, oh crap, I'm sorry guys, my bad. And it stops. But if it doesn't and it becomes a significant problem, what's your options at that point? Is what I just talked about an injunction prohibiting workplace harassment in play? No, we're not dealing with a harassment health safety issue. We're dealing with a rogue director, and he is rogue by doing this. That's engaging in selective enforcement. That's part 2 of this answer. Part 1 is, how do you get him to stop disclosing? Well, if he's going to absolutely refuse, we can go to the court, like I said, and get an injunction against him, and he's going to be responsible for the attorney fees for that. Now, how do you deal with the selective enforcement? Well, again, the community should not be sending violation letters because of what one board member is saying. It should be the entire board. And most management companies have a management contract where it gives them as the agent authority to send out what they should be sending, what they shouldn't. So, and number three is if they are an officer, in this case, I think you said he was the president, just a board member. Let's assume he's the president or vice president or whatever. The rest of the board can not necessarily kick him off the board, but they can remove him as president and appoint somebody else as president. So those are some of the options that I would go through in this example. I would not want to file in court until it's the very end, and it depends on the type of harm that is being caused to the board and to the membership, and the type of liability. When I say harm, I'm talking about liability. I could be talking about actual damages. Let's say the dude's dumping toxic waste into the lake, diesel fuel into a lake. That's harm from an actual damages perspective, that you have to get stopped, and you'd call the cops for that one, right? But we're not talking about that. We're talking more about liability being a harm. What is wife's access to executive information doing to harm? And then obviously posting it in a public forum like Nextdoor, that's significant harm. It's exactly what McNally was doing from an oral perspective. Not she wasn't doing it on social media, but this is exactly what was going on. And like I said, the Court of Appeals said, essentially, you could have done this if you were authorized to do it in your bylaws or articles. But when your bylaws and articles don't authorize you, here's what you can do. So that's how I would work that one. Oh, by the way, in that one, it's a pretty long thing, but assuming he is verbally abusing, verbally harassing everyone, including you, the rest of the board, and just steamrolling everyone, the remaining board should meet with their attorney if it's getting to the point of just, we can't deal with this anymore, and get advice from the attorney for the association without him there on what to do about this specific example. All right. What if the whole board, we'll end on this one. And then I'll give you a little pitch into our next month's class, which is going to be fantastic. What if the whole board is rogue? Yeah, we deal with that sometimes, right? What do I do as the attorney when the whole board is rogue? Sometimes I just have to resign.
Cancel the contract.
Yeah.
Stop attending.
Yeah, it's scary when a whole board is rogue, because whatever they're doing, no matter what you tell them to do, what they're going to keep doing it. And at some point, especially if it's causing harm, somebody's going to get sued, and you don't want to be part of that. You want to document the file and get out of Dodge. So especially if the whole board won't remedy things. Hopefully in the next election cycle, some reasonable people will get on the board to solve that. But apathy's an association killer. So if there's an apathy problem in your community, you don't see this rogue board going away anytime soon, you should seriously consider terminating the contract. At least that's what I try to do now. All right. So with that said, because although, by the way, in order for me to act against a rogue director, I have to have my client, the board, make that decision. I can't just do it unilaterally as the attorney. I have to get client permission. So I ethically can't take action against a rogue board when the entire board is rogue. That would be going after my own client, putting myself up in an adverse position against my own client. And that's clearly a problem. Can't do that. Same analysis for you guys, I think. You don't have the ethical requirements like I have, but I would think from a business perspective, you don't want to touch that board. That sounds like too much of a hot potato. Okay, next month's class. This was an idea that came up a couple weeks ago and part of our surveys. So I would love each of you, and we're going to send out an email for everybody, to come up with the craziest story you've ever had as a manager or a board member or whatever. The craziest thing that's ever happened to you. And you're going to email that back to us after. You don't need to reply. I'll just reply to our office. And we're going to gather all of those, and we're going to select and prioritize them from one down. And we're going to go over them and address each one of them from a legal perspective. And at the end of the class, we're all going to vote on who had the craziest example. And the winner gets a Christmas gift, or I should say a holiday gift. So I'm super excited about that one. It should be a riot. We should end the year with a couple of laughs of just the craziest things, because I hear this from all of us all the time, right? We could all write a book on all the crazy stuff that happens. And but I've never done a CMCA approved course on it. So let's do it. So that'll be the end of the year class to close this down for 2022. Thank you so much for joining. It's been great having you here. If you had a crazy example that I didn't get to, I know there's several of them here. I'm so sorry we ran out of time, but feel free to shoot me an email direct if it's a real serious question you need addressed, or submit it for next month and hopefully it'll make the list. So until then, have a
Thank you,
wonderful week.
Clint. You made it so much fun.
Thank you, everybody. Bye-bye.
Stevie.